suggesting, Your Honor.
It was. It was. You said he can't shirk his discovery responsibilities by signing a document, sending it off, and then say, I don't have it. So right now, your credibility with me, Mr. Axelrod, is about none, if you understand that.
I do. I certainly do, and I apologize when you feel that way.
And let me say this. I mean, y'all made a lawyer like that in Philly or New York or D.C. or wherever the heck it is, or Miami. We don't lawyer like this around here.
The subpoena that Mr. Friedman served on Ralph Otto and the entire civil board fleet that he did not share with us, I can share that with you too.
Your Honor, if I may respond to that, my cover email to Mr. Otto states, it is our understanding that you may be arriving in Florida to testify. When you land, we intend to serve you with a trial subpoena requiring your attendance, and that requires you to bring certain documents with you when you testify. To that end, we are attaching a courtesy copy of our intended subpoena in advance so that you can have more time to gather the documents, and then when served, it will make compliance easier for you. We then ask him to tell us when he's arriving to make it more convenient for him and the process server, or ask if he will accept it over email. This was not service of a subpoena. This was service of a courtesy copy so that when he landed, we would hand it to him, and then we would bring it to your attention to say, and to them, and to say, hey, we have now tagged Mr. Ralph Otto in Florida with tag jurisdiction. He now has a valid trial subpoena to produce documents to us. We were never able to tag Mr. Otto, and so we never ended up serving the subpoena. I was very clear it was a courtesy copy, so I take issue with Mr. Axelrod's half disclosure to the court about what I did. Also, Your Honor, I must take a moment to correct.
Before you do that, is that what the cover letter said?
I don't have the cover letter in front of me, but there's a certificate of service that says, I hereby certify that the foregoing documents was furnished to all counsel of record by electronic mail on this 6th day of January 2025, the same day that it was sent to Mr. Ralph Otto. And it was never served on us.
Your Honor, may I approach? Here's the cover letter. My paralegal prepared a courtesy copy. It says it. On my honor and as an officer of the court, it was a courtesy copy. We said it straight out. It is true there's a certification in there, but that's just because I asked my paralegal to prepare a subpoena so we could send it to her, and she simply filled it out. Your Honor, also, if I may just, I feel compelled to simply correct the record because my client has been labeled a liar over and over again. The document, Mr. Young said it was a wet signature, and as you'll see on the document, it is not signed by Helios Global, which means, as Your Honor pointed out, he executed it and then sent it, he mailed it back to Helios Global for execution. So he did not have it to produce in discovery. My client has never lied in this litigation, and in fact, when asked about whether he signed an agreement with Helios Global, admitted it on the stand. Mr. Axelrod was not prepared for that admission, went to impeach him after there was nothing to impeach. And if the court looks at the transcript, you'll hear my objection. He says, I'm going to impeach him. And I said, what are you going to impeach him for? There's nothing to impeach. So he has told the truth over and over and over again. The only thing he hasn't told the truth about is that he didn't know that as of 2022, Helios dropped his security clearance. He had no idea. CNN knew and failed to produce those documents to us when they obtained the documents from Helios Global. And, Your Honor, then when the court inquired about how CNN obtained these documents, CNN lied again by saying it was just luck, that it was just sheer luck that we got it. It was not sheer luck, Your Honor. It was the secret subpoena that was sent out. And, excuse me, when the court looks through the questioning that you've just seen, you will see that Mr. Axelrod left the jury with the impression that Mr. Young was doing contracting work with Helios Global, something he knew was not true, and which echoes the statements he made to you about Mr. Young committing a fraud on the court, which of course is not true as well. So, you know, and in terms of not listing Helios Global as a witness, of course we didn't, because we didn't have this document, Your Honor. And so this document was obtained outside the bounds of discovery. It was hidden from us. It was thrown at us as a surprise. We are now prejudiced, and the relief we're looking for, quite frankly, Your Honor, is conservative in my view.
They were not prejudiced, Your Honor.
And, Your Honor, they put an expert on the stand yesterday that said he still has a security clearance, he's great, he can do all the work he wants. They knew it's not true. They had their expert get on the stand and say, he's got a security clearance, no problem, he can get work. They knew it was not true. We did not, they did.
That is false. Mr. Young testified he still has a security clearance. We had no idea that that's not true.
Your Honor, if I may, they knew it's not true because Helios Global told them it's not true on January 2nd, 2025. In their letter, they said, we retained Mr. Young's clearance through approximately November 2022 in the event these requirements reemerged. But they did not. Ultimately, we administratively dropped Mr. Young from our security clearance roles, thus ending any relationship/affiliation. So CNN knew that there was no security clearance in place, something we didn't know because we didn't have this communication.
Well, they knew he didn't have it through Helios Global.
Correct.
Well, that's true, Your Honor, but that is, I mean, Mr. Young testified he has it through no one else, and what his testimony on the stand was that Ian Conway did him a solid by keeping his security clearance, and I hope, he said, I hope I still have it, if I remember correctly. I'm trying to remember. So clearly, Mr. Young's testimony was the security clearance is through Helios Global. And that was the only evidence that there was a security clearance. CNN knew that that relationship ended, knew Mr. Young did not know that that relationship ended, had proof of it, and failed to disclose it to the other side, and then put an expert on the stand to say he still has it. Your Honor, I'm not sitting here asking for sanctions. I'm just saying we have been massively prejudiced, and we should be able to clear the record. The jury should not be misled.
Your Honor, you can't be prejudiced by introduction of a document that you knew existed. And you already found in the spoliation order that as of December of 2021, Mr. Young knew he was going to be bringing this lawsuit or was contemplating it. You can't get around your discovery obligations by signing a document, then sending it off and saying, I no longer have it, can't produce it. That's what happened here. I mean, he got the contract.
I sign a document, send it off. It's within a company's possession, custody, or control. What is my discovery obligation to go to their records, dig through their files, and find a copy of a document I signed several years ago?
But that's not what I was suggesting, Your Honor.
It was. It was. You said he can't shirk his discovery responsibilities by signing a document, sending it off, and then say, I don't have it.
He had it, is what I'm saying.
I get Porter to read back exactly what you said, but I think I verbatim said exactly what you said.
Your Honor, the point I'm trying to make.
I'm tired of these blatant misrepresentations that are being made, and they're being made by both of y'all. And maybe they're not 100% lies, maybe they're leaving out a little bit of the truth in making representations so you can carefully say, well, I didn't exactly say that. But you said he's lied to it because he doesn't have any work, but you had no proof that he had work because you're arguing that he signed a security agreement so they could hold his security clearance. But I didn't lie and say he had work. All right, we're taking a break. I'm going to go read this real quick. Let me ask you one last question, Mr. Axelrod. You said, we were going to call Helios Global or whoever it was from there as a potential rebuttal witness. And that's why we served a subpoena. We didn't need to list a rebuttal witness on our exhibit list. But you also had production of documents from non-parties. I remember reading 2 motions to quash that verbatim said Rule 1.351 expressly provides the rule that is the exclusive procedure, in quotes, the open quote, exclusive procedure, close quote, for obtaining documents from non-parties without a deposition. Your subpoena for trial to whomever at Helios had a production request. The motion also says that the motions that I remember reading said that 1.351 requires the notice to the other side. How are you not conducting discovery pursuant to 1.351 in sending a subpoena ducis tecum to Helios Global without giving notice to the other side?
Judge, I'm going to take ownership of that one. I called Mr. Friedman this morning after reading the motion. I was asked to prepare a trial subpoena, and the subpoena came across my desk. My paralegal asked me if we needed to send notice of this to the other side. I told her, no, it's a witness subpoena in 38 years. I've never served copies of witness subpoenas to the other side and don't recall getting copies of witness subpoenas. I was looking at it as a witness subpoena, not a document production request. There was a ducis tecum component to it. I don't recall seeing it, but it was there, and I'm responsible for that. So if the rule requires notice of a witness subpoena that has a document production request to it, that's on me, and I take responsibility for that. And I told Mr. Freeman that.
All right, well, and Mr. Axelrod made the representation that fortuitously we ended up just falling into our lap at the last minute. But it wasn't fortuitous because it was pursuant to that witness subpoena.
That is true. Mr. McManus did send it, but we did want him to come testify. That is correct.
All right, I'm going to go look at this. I'll be back. All right, I went back through and I was reading the trial transcript that preceded the sidebar and then adjourning with the jury and the discussions that we had with the Helios document that was handed, 589? I think defense 589 was the document that was handed to Mr. Young during the cross-examination. I think I made comments throughout the course of this case about how counsel was conducting themselves, how everything was a surprise, a last-minute thing, how counsel was referring to each other in the course of their arguments, had to impose a $100 fine. I find it rich that we've got discovery being done at the same time a motion to quash is being filed, arguing that the plaintiffs are violating the rules by sending out trial subpoenas when the defense is doing the exact same thing. We have representations being made to the court that we were just fortuitous to get this. It wasn't fortuitous. It was you were doing the same thing that the plaintiffs were doing and sending a trial subpoena for documents without notice to the other side in violation of Rule 1.351 that y'all cited in a couple motions. And just saying that this showed up in our lap. You represented me this morning. We didn't accuse them of anything, of having anything beyond a security agreement. But that was clearly the implication that was being made when we were arguing about the document because you wanted to impeach him with it, despite the fact he admitted to signing a security document. Then you changed it. We want to use it substantively, and it got admitted into evidence. And it was admitted into evidence under my Binger analysis of something that, there's not prejudice to the other side, was primarily the reason. Had I known it been discovery being conducted after the deadline, there was no way in hell that the document would have been admitted into evidence. Mr. Axelrod, I don't know how many times in this transcript, I didn't bring a piece of paper back with me, how many times you called Mr. Young a liar.
Yes, Your Honor.
But yet in his deposition, he acknowledged having his security being held by Helios Global, which is exactly what that document is and which was exactly what he testified to. I think an apology from you was clearly in order to Mr. Young for the number of times in front of this court and streamed around the world that you call Mr. Young a liar for failing to disclose a document that you have no proof was within his possession, custody, or control. Everybody here, I don't know how much money we're clicking off an hour in lawyer bills in this case, and how much credentials the lawyers have in this case. The case has been pending for 2.5 years in my court. And I made a joke, looking back through this transcript, I made a joke of you only have a week and a half to do more discovery in this case till we finish up the trial. But it seems like everybody wanted to do everything at the last minute without telling the other side that we're going to do this discovery and then accuse the other person of being the bad person. And I said in this transcript, I'm not going to decide the case based on who can sling the most mud at each other and make each other look out to be the worst person. think it came up in the course of things. This isn't kindergarten. Y'all matriculated from kindergarten a long, long, long time ago. Or at least that's what it says because y'all have bar licenses. I'm troubled by all of this that happened. The easiest thing and the clear thing I'm doing is I'm permitting you to call Mr. Conway and get him here to testify and rebuttal. But I'm overly concerned with the level of professionalism or lack thereof that's here. I'm overly concerned. I mean, the transcript of what I read, we said at sidebar when we were arguing after we excused the jury, conflicts Mr. Axelrod with the argument you made today to me. The argument you were making when we were arguing about the document last week, you were suggesting that, oh, we got the smoking gun. This is the crucial document in our case. I don't know how many times I've heard that from both sides in this case. Or the crucial witness. I think every document, the thousands of documents we have in evidence in this case, are the crucial documents. But this was being represented as, oh, this just fell out of the sky in our lap, not that we were doing the same thing we were accusing them of being bad people to do. And I take that as a complete insult to me as the court in this case. And you were saying that he completely lied and misrepresented despite the fact he acknowledged that he had a security clearance with Global, which again is another misrepresentation of the court which supports your argument that you were being made. So right now your credibility with me, Mr. Axelrod, is about none, if you understand that.
I do. I certainly do, and I apologize when you feel that way. I apologize if you feel that I've misled you. That certainly wasn't my intention.
Yeah, well, you said, oh, I never said that. Well, no, you did. So today you said I never said that, but that's what the transcript from last week was representing. I'm reserving on any other sanctions pertaining to this matter and other matters against the lawyers of the parties in this case. But at least to resolve the issue for this morning to go forward, you can get Mr. Conway here. And I'll do this too. If Mr. Conway cannot make it here, we can call him via Zoom.
Thank you.
All right?
Nothing further.
All right. Is there anything else we need to get before we get the jurors in here?
No, Your Honor.
All right. And let me say this. I mean, y'all made a lawyer like that in Philly or New York or D.C. or wherever the heck it is, or Miami. We don't lawyer like this around here. Y'all may have handled some big cases. We're not going to play the shenanigans anymore in this case. Y'all both understand that?
Yes, sir. Yes, sir.
And I'm upping the fine for personal insults to $1,000 per time from $100.